Hey, looks like somebody sent us this bit of winter. This winter with cheese. This is Theron J. Mars, or as he likes to go by here, TJ. YouAreLaw.org. Ooh, You Are Law. Teach us how to do it, You Are Law. Oh my. What is voluntary tyranny? When it comes to winning a legal matter, we perish for our lack of, in quotes, knowledge. Why'd you put that in quotes? Not our lack of a so-called, in quotes, good lawyer. Huh. Hey, Theron J. Mars, it looks like you have two lawyers. So, is it the lack of a good lawyer? So you got two? See our long list of success stories and endorsements here. Charges were dropped. That could happen. Not perfect, but a great asset by MJT. You know what they don't have? They don't have these things called opinions that say they're right. Now, lots of charges get dropped, dismissed, not brought, just are allowed to lapse. If you're small potatoes, then they're small potatoes. Or, yeah, if you're small potatoes, they won't. So who is this? I'm going to go ahead and read more. Santos Bonacci? What? So who is it? Who is MJT? About author MJT. Oh, look, MJT wrote all of them. Wasn't that crazy? Isn't that crazy? MJT, 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 MJT. Oh, look, MJT writes all of these. Do you think that maybe he's lying? Maybe he's lying? Oh, let's see what the comment was. Oh, God. Some poor schmuck is buying this bullshit. Nice. All right. Anyway, back to where we were. Stay respectful but firm. Yeah, that's always good. I mean, even like if you look at the way lawyers act in court, we actually know what we're doing, and we still say, yes, Your Honor, no, Your Honor, thank you, Your Honor, if it please the court. It's always good to be respectful, especially if somebody has your balls in a sling. You need him to like you if you want to win. Presumed contracts are not a contract. Is assumed a word? Let's see. Presumer came from to dare, to anticipate, to assume. And he has it what? As pre equals no. He took a portion of the word away, thinking that pre was a prefix. That's a level of genius I have not encountered often. There are such things as implied contracts or quasi-contracts. I'm not sure where he's going with a presumed contract. I'm not going to listen to this whole damn thing to find out. There's enough crazy in my life. does not require knowing statutes and codes, one simple procedure. Well, you don't really, I mean, if you're going to go in pro se, you don't really have to know statutes and codes. You can make an argument from just pure logic kind of thing. Like, the court gives pro se litigants a lot of leeway as far as like trying to figure out from the garbage that they write down on paper what they're actually trying to say. So you don't have to know the statute. You could say like, you know, I didn't harm him or something like that, you know, or whatever. And the court will try to figure out what statute or code would apply best. I don't know why sovereign citizens love to try to throw up statutes and codes. No. What are you doing? So the Code of Laws of the United States of America, USC, U.S. Code, is the official compilation and codification of the general and permanent federal statutes. So I don't really understand why sovereign citizens try to split hairs between statutes and codes. Doesn't really make a whole lot of sense. But then again, they're sovereign citizens, so making sense really isn't their forte. So you could use this system primarily in traffic. Okay, it's basically a criminal-esque procedure. It's like a stripped-down criminal trial. Criminal, which would be a full-blown criminal trial. A child support, would that be like a hearing? And even a lawsuit by a third-party debt collectors or a tax agency. Oh, so this works against the tax agency, huh? It works against the tax agency. He made this video on May 18th. Somewhere between here, where the court had to reset a hearing to once the parties comply with the court order. I wonder who's the problem there. And here, where the motion to dismiss and motion for discovery were made, or rejected, I don't know exactly. Probably made. I don't know, buddy. You've been sucked into this thing for almost a year now. You're getting close to a year. I don't think your simple solution works. I don't think your system works. Then finally it says put all the burden of proof on the accuser. Well, normally the burden of proof is on the accuser. So I don't know what you think you're doing. The accuser has to prove in a non-criminal, in a civil case, it'd be by preponderance of the evidence. In a criminal case, it would be beyond a reasonable doubt. It's the burden's always on the plaintiff or the prosecutor, so I don't know. Keep doing that only with questions and or conditional acceptance. I don't know, man. You could ask inane questions all the time. Just ask what's that guy's name? Something about whose claim is it anyway, or something like that. God, all I could do is ask questions. The most inane questions. It doesn't get him anywhere. This won't get you anywhere. Not legal advice. This looks like it's legal advice. Results will vary. Sure will. Sure will. The author assumes no liability for outcome. There's more to know than the simple video can convey. Yeah, I guess you got to go here and let's see. You could join or upgrade membership. Forensic analysis of legal document services. Criminal case system. Slam dunk. It's a slam dunk criminal case system. It's a slam dunk. He's been up to his elbows in this for a year now, but he's got a slam dunk case system. This is it just shows you how awesome he is. He sued the United States in an Oregon small claims court. He sued the United States in a small claims court. God. Oh my God, you gotta be kidding me. Failure and inability to state a claim. Oh my God. Oh Jesus. Oh yeah, so he doesn't get his default judgment or his motion to remand to the Mars court. Likewise, he didn't get too far on this one where he sued U.S. Bank. It was dismissed. This one dragged on for less than a month before it got dismissed. Boy, he just couldn't get out of the starting gates here. So, petition for bill of equity. Statement of indenture, order for camera evidentiary conference. I mean, Christ on a cracker. Evidence A through F. Sealed supplemental documents. Boy, he just went to town. Motion to seal and proceed ex parte. A motion for permanent injunction, or alternatively a motion temporary restraining order. Okay. Supplemental exhibits. A filing fee of $400. So he paid $400. Let's see. So was this granted? Plaintiff's request for a temporary... Oh, no, it was denied. I'm sorry. My eyes are getting tired. So his restraining order was denied. A minute order. Okay. Motion for permanent order is noted. So he's electronically filing. He amended his complaint. A motion to reconsider with evidence. Okay. Denied. Oh, he got an authorized order regarding discovery and depositions. Nice. Status conference. I swear you spend more time in status conferences as a lawyer than you do in court. Well, I guess status conferences are at court, but you know what I mean. Like 50 status conferences and then like half a day in court for the trial. It's pretty ridiculous. We really want you guys to settle out of court. We think it'll save you a lot of money. It'll save the system a lot of money. I don't know how, but okay. Oh, the IRS sent a response. So the IRS is involved in this. An order denying plaintiff's petition to seal and proceed ex parte. Yeah, I don't know why. So ex parte means, without the other side being there. It just seems normally you would. So, like, in family law, you see a lot of ex parte motions. If you need to get something done quick, you'd file an ex parte motion to get a quicker date on a hearing. Like, oh, my spouse is going to move out of state at the end of the month with the 2 kids, and I want to keep them here, so I'm going to file an ex parte motion, and the judge will hear you on that. You're supposed to notice the other party, but whether or not they show up is up to them. Because sometimes you don't even have to notice them until, like, after you've gone. Just depends. Anyway, and then, like, you can ask for, you can request to have an order granted, and sometimes they'll do that. Like if it like a temporary domestic violence restraining order, something like that, you can get something like that done. The judge will sign that without giving the other party a chance to do anything, but then there will be a hearing later for it. So yeah, in family law, you see a lot of ex partes. I don't believe you would see a lot of ex partes in a civil suit. It looks like a civil suit of some sort. Some sort of injunction or something. I don't know. So he's trying to proceed under equity. He's not proceeding under, like, statute, but I don't know what he's going for, like unjust enrichment or like a restitution kind of theory. So then you've got so the IRS was either got involved or they were an interested party, and they oh God, what's that? Where they what is that? There's a motion you can do to if you're an interested party to get added onto the lawsuit. Joinder? I think it's some sort of a joinder. Sorry, my brain's shutting down. Ooh, that dog fart was terrible. Ooh, delicious. All right. So you have minute order. Motion for an injunction is noted. And amended complaint against the IRS and the U.S. Bank. Okay. Supplement to a 12 motion. A 12 motion is like a motion to dismiss federal complaint. Like a 12B6 is a motion to dismiss for failure to state a claim. FRCP Rule 12. So 12B6 is failure to state a claim. That's what you see a lot. I don't know what other one they were doing. I don't know what other Rule 12 they were on about. Where was I? Oh, this one, yeah. So it looks like he was fighting a motion to dismiss of some sort. Motion to amend complaint. Motion to reconsider denying. Order regarding discovery and deposition. Order regarding initial disclosures and joint status report. So they motion to seal. order deny plaintiff's motion to seal and proceed ex parte. Order on service of process. Motion to dismiss proceeding. There we go. That's a proposed order. There's a response to his request for permanent injunction. So the judge denied the permanent injunction, and then TJ I don't know. He withdrew. He tries to withdraw without prejudice, but I don't know if it was actually dismissed with or without prejudice. So that'd be interesting to figure out. Ooh, let's look at the parties here. Can I? Can I? Can I? You're not gonna let me. All right. Well, we'll do this. There we go. Huh. I don't know why they list IRS as a defendant and a respondent. That's weird. It doesn't even look like US Bank even had to send a lawyer or do anything. They're just like, yo, IRS, this one's on you, buddy. Go get him. So yeah, his system is garbage, and if you believe it, well, there's nothing I could really do. Thanks for watching. Have a great day.